It is May 7th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. The excuses are as wild as the charges today. We've got a dad taking the fall for his son's unshoveled snow, a driver who thought 82 miles per hour was the safest way to pull out of a bar, and an intake interview that goes so wrong the judge revoked bond on the spot. We'll also see a time-traveling pill prescription, a defendant begging to hit Cedar Point, and a breathalyzer test outsourced to a 13-year-old. Plus, the ultimate defense for breaking into a daycare at night. I just really needed to use the bathroom. Strap in, kids. We've got all this and more. And it all starts right now.
Against Robertson, Jeremy Robertson, file number 25WA37064. Your name? On March 4 of 26, I sentenced you. There was $1,831 to be paid, including restitution to Lowe's in the amount of $1,146. Let's see. I also allowed you to pay that at the rate of $150 bi-weekly beginning March the 13th. The charge that I have in front of me alleges that you failed to pay your fines and costs as ordered. $1,831. Do you understand that? Did you sign, read, and understand an advice of rights form? Yes, sir. If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or trial of any kind. Do you understand that? You have the right to a lawyer. I'll be happy to give you one at public expense. Do you understand that? Would you like a lawyer? Are those sunglasses or what are those? I can't hear you.
Here's transfers.
I still didn't. Okay. Yeah, I'd encourage you not to have those on when you come back unless you need them for vision. Okay. All right. So I will go ahead and enter a not guilty plea. I'm going to give you a lawyer. And, we will go from there. So I'm entering a not guilty plea. We'll give you a probation lawyer. You'll meet with them. Either way, you're coming back in front of me. Okay. Any questions? I can't hear you. Just need to keep your voice up. Okay. Good luck. Chestnut. Elvin Daniil Chestnut II, 260-648303A, B, and C. Could I have Keith Gross seated at the table, my right, your left? Sir, your name?
Chestnut.
You're charged with driving on a suspended and expired plate and no proof of insurance. You have the right to a lawyer on these. If you want one, I'll give you one. Do you want a lawyer?
Yeah.
Okay. Okay, it's just going to take a little bit of time. Okay. So I can arraign you. I'll explain the charge, the possible penalties, and your rights, and then you can go talk to the prosecutor. Okay? On April 13 of 26, it is alleged that you did operate a motor vehicle on Fort near Harrison and Trenton at 5:05 p.m. with a suspended license. That is a misdemeanor. It is punishable by up to $500 fines, 93 days jail, costs of all those 2 points. Do you understand that? You also have an expired plate and no proof of insurance, 0-point civil infraction charges. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights form? You plead guilty, you will be giving up all those rights, and we will not have a hearing or a trial. Do you understand that? You understand that? You still wish to waive your right to a lawyer?
Yeah.
All right, I'll enter a not guilty plea. I'm going to have them give this to the prosecutor. And he will call you in, okay? Any questions? Good luck. Keith Allen Gross, 26G82668. Come on to the podium, sir. It's all right. Your name?
Keith Gross.
Okay, so you're charged with failure to respond to a civil infraction. So apparently they issued a civil infraction, they think, and you didn't respond in any form or fashion, so they filed a misdemeanor charge. The charge is a criminal charge from failure to respond to a civil infraction. It is punishable by up to $100 fines, 90 days jail, costs are all those. Do you understand?
Yes, sir.
You have the right to a lawyer. If you want one, I'll give you one now.
I don't get water.
Okay, they think that this happened at Mar Street, 30348 Mar, in the city of Gibraltar, February 17 and 26. It says they issued you a civil infraction on January the 28th. And that was for failure to clear snow from the public sidewalk after being warned previously. So this is a misdemeanor, punishable by up to $100 in fines, 90 days jail, costs are all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you will be giving up all those rights, and we're not going to have a hearing with a trial of any kind. You understand that?
Yes, sir.
All right. You still wish to waive your right to a lawyer?
I do.
Not guilty plea, I will enter. I'm going to give you $100 personal bond. You don't have to post any money. Here are your bond conditions. You cannot leave the state without the consent of the court. Violate the law. You must appear in court as directed. Okay. So you go down the hall. We're going to give this to the Gibraltar prosecutor. He will call you in when he is ready. Okay.
Judge, can I say something? We spend our winters here in Florida. And we were just made aware of this one day.
Go explain that to him. Okay.
Thank you.
Go explain that to him. All right. I don't know what happened here, but
Well, the son resides at the house and when we finally called him after I got the paperwork, yes, Dad, I did get cited for it. Why didn't you pay it? Well, I don't know.
I see. So your son did this to you.
Yes.
See,
Gotta love him.
you and I are about a month apart. Okay. I look at your birthday. That's what happens, isn't it? Go explain your situation to the prosecutor. All right.
Down the hall.
No, right outside there, Gibraltar, you're going to go to conference room number 3. So that's going to be right outside the doorway there, and then to your right on those pews. Okay. To Bradley Lawrence Gaia, 26B12 150513A.
Good morning, Your Honor. Peter Granada, P78413, MIDC counsel for Mr. Guy.
All right. So he pled guilty to impaired. The OWI was dismissed.
Yes, Your Honor.
Who's got the phone? Whoever's got the phone, go take it out of the building, please. All right. I'm sorry.
I've had a chance to go over the PSR with Mr. Gaio. We don't have any additions, subtractions, or corrections. The only thing that we would ask the court to consider is, again, community service in place of court work program, if the court so deems that part of the sentence.
How many times you been in trouble?
Speeding ticket.
You've never had a criminal charge before. So I'm not saying I necessarily agree with this. You were in the ditch, right?
Yes,
You were by yourself, right?
yes,
Nobody else was struck, right?
yes. Correct.
Were you truthful on the screening? And this was a breathalyzer, correct?
Yes.
Do you want to say anything? You want to do all this stuff that they ordered you to, that they want you to do? Did you review this report? Pardon?
No, I did not.
You think you need it? I don't need it. According to the statute, there's really a presumption that you don't, that I'm not supposed to put everybody on probation. In other words, it's presumed that probation is not necessary on this type of offense. You get a 116 and a 113. Yes, you did drive into a ditch. Yes, you did admit to the police you were screwed up. Yes. You did test in category 1 on the alcohol use portion and the drug use portion. So I can't rationalize this in my mind, even though I might disagree with the law. That's not my province. $300 in fines, $350 in costs. That's $650. You have 75 victims' rights fee, $50 justice assessment, $775. Screening fees, $60 for $835. Cost of recovery is 50 for $985, $150 for $985, and I'm going to charge you $40 in attorney fees. Your total is $1,025. I'm also going to order that you serve 3 days jail credit, 1 serve 2. I'll let you serve those by way of community service. So 2 days of community service, 16 hours. You're gonna do that by. I'm going to give you until June the 30th to complete that. I'm not placing you on probation. I'm going to also order. I want you to do the victims impact panel too. That's one night put on by Mothers Against Drunk Drivers. Anybody who ever drink should do that and driven. So I'm going to order that. So victims impact, 2 days community service by June the 30th. Fines cost $1,025. And you are all set. If you violate, though, if you don't pay your fines, or if you don't do the victims impact panel, if you don't complete your community service, you could get 93 days with credit for any time served. Do you understand that?
Yes.
You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? Stay out of here, will you?
Judge,
See you again. All right.
Judge, he
Thank
also
you.
did have the distracted driving that was reduced down for 155 with that one too. That he pled to at the last hearing.
Correct. I'm sorry. You also owe 100. I'm going to charge you 150 on the distracted. Okay. They dismissed the open intox. So you owe 1175. Can you pay all that, or do you need some time? Okay. So you pay this now. You'll meet with probation now. I sincerely wish you well. Don't come back though. Okay.
Sure.
Have a great day. Thank you. Keith Allen Gross, 26G 82668. Good morning, sir.
Morning, sir.
So they understood, huh?
Yes.
Your name?
Keith Gross.
Case dismissed, motion of the prosecutor. Have a great day.
Thanks, sir.
Good luck.
Thanks.
Counsel, which one do you have in front?
Here, I have Ali.
Okay, come on up on that. Ali Abdullah Ahmed, 25T 6470779 A and B.
Wait, E6489, yeah, Mr. Ahmed, he's to my right, Your Honor.
Good morning. Your name, sir?
Ali Abdullah.
Did you pre-try this or not?
Not yet, Judge.
Do you want to just, yeah, I see, rescheduled it. So you're going to stay on mute, wait for my reading?
Yes, Your Honor.
And then what do you want to do? Do you want to go talk to Trenton's prosecutor now, or do you want to come back? It's up to
We
you.
can do it now.
That's fine. I'll enter
Judge.
a not guilty plea. Take this over to, well, you can take the file over to him, Mr.
Yes,
Woodburn.
sir.
I'm gonna give him listen, you're not gonna play this game with me though, are you?
No games, Your Honor.
Him, I mean, not you. Him. He didn't show up. This was from December of 25. Why weren't you here? No, the guy in the hallway. Who do you think I'm talking to?
What days I'm on?
You're supposed to be here first on January 15th. You didn't show up. We issued a show cause. You were supposed to be here January 29th. You didn't show up either day. Well, they gave you, listen, keep your voice up. They handed you the ticket, right? Did you follow up and call the court? Say, hey, when's my court date? I can't wait to get in there to take care of that. You didn't do that either, did you?
Said that they were gonna mail me some,
Did you live on Ogden?
Yeah.
We mailed the things there. Okay? You got to show up. $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. If he's going to set aside the default, you better, John, give that to the Wordling. You better make sure that he sets that aside, okay?
Good times.
Swinney. People against Chelsea, June Swinney. 26G 306-968.
Good morning, Judge. I'm having good feedback from school. Speak your full name.
All right, you got quite a breathalyzer here, young lady. Not good. All right, counsel. Did you have a chance to review? So, just for the record, she pled guilty to operating while impaired. The super drunk charge was dismissed, and she was referred for a screening and assessment. Have you had a chance to review the report with her, and are there any material additions, corrections, or deletions?
We haven't had a chance to review the report. There's no commission for that resolutions and stuff.
Anything you would like to say on her behalf?
But you said, after talking to Ms. Sweeney, she had 28 years old, Judge. She is currently employed at a company called Foundation Restoration as a permit reliever in a call center. She started working there on April 22nd of this year. She earns $18 an hour. She is full time currently. And she is also enrolled in the high school diploma program through a Monroe Learning Bank. That's an online course, Judge. She started that in January of 2026 and hopes to complete it after finishing. She's got 6 more classes before she actually receives her high school diploma.
That's good.
This is her first conviction as an adult. And she's continuing to go to AA as the court ordered, and I believe she's learned her lesson, Judge, and she's assured me that this is not anything that's going to happen again. Is that correct? Yes.
I know they're not the most. You had a larceny in 17 and 2 MIPs. So I'm not sure that should have ever been criminal. The MIPs, but still, you got to be careful, right?
Yeah.
All right. What would you like to tell me, young lady?
Well, that I've learned my lesson in 52 days sober. It was great.
Good.
Finished school.
Well, that's fantastic. Good. Good. And you're trying to get your GED.
No, diploma.
Diploma.
I mean, that's what I meant.
Yeah.
Diploma.
Okay.
I get it. Well, I'm glad you're doing that because I would have ordered it anyway, and I'm going to order it today. 13 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You do have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. I want the kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs and ETGs as follows. I'm going to make it bi-weekly for 4 months. If you're clean, I'll then make it monthly. Okay? You understand that? I want you to attend AA once a week. I'm going to order outpatient treatment. Once you get in outpatient, you no longer have to attend AA or NA. So AA once a week until an outpatient. Once you get in outpatient, you can stop going to AA. Every time you go to AA, you have to have the form signed, and you're going to show it to probation when they have you go there.
She definitely do it, Judge. She did order it once a week, so she did have it. She could show it to me.
Right. And I gathered that. And then the victims impact panel, attend that, complete that. Okay. 4 days jail credit, 1 serve, 2 days on the court work program, 1 day of community service. Your community service has to be completed in this case by June the 30. 2 days court work. There's a $35 a day charge for that for a total of $70. You are to obtain and maintain employment and provide proof if they required, obtain a high school diploma or a GED. So that's perfect. 300 fines, 250 costs, 75 victims' rights, $50 justice assessment. So fines and costs here amount to $675. Probation fees are $260 for $935. Screening fees $60 for $995. Court work program fees are $70 for $1,065, and there are costs of recovery of $150. Your total here amounts to $1,215. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that? All right. You may be eligible for early discharge. If you can do all this and there's never a violation, at least within the preceding 90 days, after 6.5 months, you can apply for early discharge. And by statute, you're entitled to it. Do you understand it? If you violate, again, you could get 93 days. You understand that? All right. How much of this can you pay today?
I just started, so I haven't gotten the first check yet.
Tell me how much you pay weekly.
Get paid bi-weekly, and I haven't got it yet.
She just started on the 26th.
I know, you're making 18 an hour, right? And you work 40 hours, right? Is that yes?
Yes.
That's 720, that's 1440. The government's gonna gladly take their share of your taxes. How about $70? Look, make it $60 bi-weekly. How's that? And I'll start that beginning June 1, but just recognize that if you do not pay and you do not show up, we're gonna issue a warrant. If you don't have the money, it's not a problem. Just call the court. We'll go on Zoom. I'll be more than happy to give you an extension, okay? Just don't ignore them. You can either walk up here or call on Zoom and I'll give you an extension. We understand one another, right? Okay, good enough. Wish you well. You'll meet with probation. Go down and you'll meet with probation across the hall. They'll explain everything to you and we'll go from there, okay? Good luck. All right. Gavian Evans. 26G306739.
Just already judge and ask if it come back to Mr. Evans. Mr. Evans did the full name.
Yeah, Evans.
All right. This was a breathalyzer with to the tune of 119, or intoxilizer, I guess they're calling it now. What would you like to say? Is everything in this report accurate, counsel?
We have had a chance to review the report. We have no motion for recommendations at this time.
All right. Anything that you would like to say on Mr. Evans' behalf?
Just that Mr. Evans is 24 years old. He does have a newborn child, and he is currently living with his girlfriend. He is full-time employed. And he is in the process of actually moving into a new house, Judge, and getting his life together. This is his first conviction of any type as far as a criminal matter. And Judge, I've gone through the needs assessment. I've seen the score. I would ask the court, because of the category 1 on the alcohol, I would ask the court to sentence the fines and costs on this matter, Judge. He doesn't have any prior history with any type of alcohol conviction. And also the numbers are the breathalyzer, Judge, was, or the BAC pieces.
He's a little young to be in here. That's all. Let it go with that. That's what bothers me on this one. I'm sure he's a nice man and all that, but I just can't justify that here. I'm not going to order outpatient, but I'm going to order a level 1 alcohol education, and we'll go from there. Okay.
Thank you, Judge.
Anything else, Mr. Gaith?
Nothing else on my part. I don't know if Mr. F.
Would you like to say anything, sir?
No.
All right.
But actually, so being on probation might, do I have to stay in the state? Since I do go, to Ohio sometimes to
For what?
work on trailers.
For employment?
Yes, I'm, a mobile mechanic.
Okay. Is that the only state you go to?
Yeah.
Anything else you want to tell me?
No.
All right. 10 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance, but I will let you leave the state for employment purposes without consent of the court. You cannot violate any law, as I said. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. You're submit to chemical testing, PBT, and ETGs. I'll note that the category 1, he scored in category 1. So I'm going to make it monthly for 6 months. If you're clean, then I'll make it on demand. I'm going to make you attend. You're going to attend a level 1 alcohol education program and the victims impact panel. You're to obtain and maintain employment, provide proof of that. You're to serve 4 days jail, credit 1, serve 3. I'll let you serve those by way of community service. So 3 days of community service, I'll give you until June the 30th to complete that. You can do it at any nonprofit organization, okay? 300 fines, 250 costs, 75 victim charge fee, $50 justice assessment. So your fines and costs are $675, screening fees 60 for $735, probation fees are $240 for $935, and the cost of recovery is $150 plus attorney fees of $40. Your total is $1125. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. If you cannot afford one, you understand that. Yeah. No kratom, no poppy seeds, no CBD oils. If those are found in your system, that will be deemed a violation. Do you understand? Yeah. All right. I'm going to give you may be eligible for early discharge. So in 5 months, if you're clean and you don't have any violations within the preceding 90 days by statute, you're entitled to early discharge. Come in here and fill out a petition. Do you understand all that?
Yeah.
All right. You have all this money to pay?
No,
How much do you have?
200.
How much can you afford to pay weekly or bi-weekly?
150. Weekly.
I'll tell you what, I'll make it 75. And I'll start that beginning June 1. If you ever don't have the money, no worries. Call the court or go on Zoom on it before the due date, or you can come in here and I'll be glad to give you an extension. You just have to walk in and talk to me. Don't ignore me, okay?
Sounds good.
All right. Anything else?
Nope.
Good luck.
Thank you, Ron.
Thank you.
Ali Abdullah Ahmed, 25T6470798 and P. Oh boy.
Good morning, everyone. Once again, Ben Worley, P6489 on behalf of Mr.
Sure, your name?
Abdullah Ahmed.
All right. Sorry about that, Mr. Warbling. It's just been busy here. So he's going to plead to no ops. They're going to dismiss the suspend, and he's also going to plead to impeding. They're going to set aside that default judgment where he went into default because he didn't show, and I'm certain that he's learned a lesson on that, right?
That's correct.
I'll set aside the default judgment on this civil infraction. You're going to plead to impeding, to that charge of impeding on that civil infraction charge, with the understanding that once you plead, the disobey stop sign would be dismissed. How do you plead?
Yes.
Responsible or not responsible? All right. And to the charge, no valid ops. If you plead to that, the possible penalties are 100 in fines, 90 days jail, costs are all those. Do you understand that? He didn't sign an advice of rights. Yes, he did. He did sign one. Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or trial. Do you understand that? To the charge, no valid operator's license on person. How do you plead?
Yes.
How do you plead?
Yep.
Were you operating a motor vehicle in the city of Trenton, county of Wayne on December 13 of 25 on Sibley near Jefferson?
Yes.
Did you have a valid license with you on your person? Are you on probation or parole? Anybody force you to plead? Please accept it to that charge. Please accept it to impeding. I'm dismissing the stop sign violation and the drive while suspended. I'm ready for sentence. Anything, Mr. Worbley?
Judge, there was a point in time where we thought we had a valid license, resolved the matter in Lincoln Park. I believe it was because of no proof of insurance. That triggered a suspension period. And then it kind of spiraled past that to now where he's not valid until 2027. His girlfriend drove him today. He knows he can't drive, Judge, until he gets this figured out. I believe this ticket may have also, compounded the situation. That may change. But we're working with him, Judge, so that this doesn't, we gotta get him back on the road legally.
Yeah, you can't do this. Your record looks horrible. Anything you'd like to say? You got to stop. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 325 or 60 days, 175 on the impeding, 500 is the total. Can you pay that today?
Monday.
All of it? Are you sure? All right. If you're sure. Now, if you don't have the money, you call the court. We'll go on Zoom. I'll be glad to give you an extension on or before that due date. So I'm going to make it pay by May the 11th on both of these. Again, just don't ignore me. Things happen in life. If you don't have the money, it's not an issue. Just don't ignore me. You got to call up and get an extension. Okay? Good luck. Thanks a lot. Have a good day. Take care. Robert Aitken, Sunday Booth, 26T64576 A, B, and C. Good morning.
Good morning, Deb. I'm Brian Crane, on behalf of Mr. Booth.
Mr. Booth, your name. Boy, you're going to get out of this one pretty unscathed, huh? Looks like, right? Right, Mr. Crane?
That's a good resolution, Judge.
For you and for him, and I get it.
Yes.
What are you doing with your life?
Just work, you know.
Graduate?
Yeah.
What are you doing now?
Loan officer.
Okay. You don't want this nonsense on your record, right? So they're going to dismiss the disorderly public intox, and they're going to dismiss the recreational use of marijuana less than 21, right? And then he's going to plead to minor in possession of tobacco, and he's going to plead to loitering. Is that right?
Yes, thank you.
All right. So you're going to plead to two civil infractions, which isn't going to be the end of the world. I hope you're not. I hope you're not going to think this is okay. You don't think it's okay, do you?
No, Your Honor.
All right. To the charge of loitering, how do you plead? Responsible or not responsible?
Responsible.
And to the charge of minor in possession of tobacco, responsible or not responsible?
Responsible.
All right. I'll accept the plea to minor in possession of tobacco. I'm going to go ahead and dismiss the marijuana recreational use. I'm going to dismiss the public intox, and I'm going to also accept your plea to loitering. Okay. So I'm going to just go ahead and fine him, Mr. Crane, unless you wanted to say something.
No, we're fine with it.
150 on the loitering and 135 on the possession of tobacco. Okay.
Okay, thanks.
So you're gonna go. You have the money, 285.
Yes, sir.
All right. Don't be doing silly things like this. Okay. Have a good day. Sorry you had to wait so long, Mr. Crane.
Oh, not a problem at all. Have a good day, Your Honor.
You too.
Thank you.
All right. What do I have now? Justin Hurd. Is Justin Hurd here? Justin M. Hurd is not here. Going crazy. 26G307020. All right. Responsible is charged by default. Didn't show. Case was scheduled for 9:50. Tyler Chad Carlos, 26G306855. A and B. Mr. Stackpole, my sincere apologies. It's been busy.
You're good. Thank you, Your Honor.
I'm gonna get you out of here. I promise you. Where is Mr. Stackpole's file, though? I don't even have it. Who does?
My understanding, as I just spoke with Mr. Gates, is that he still needs to meet with them. I thought he already met with them.
He was from a while ago.
We'll remind him. Good morning, Mr. Dubin.
Good morning, Your Honor. How you doing?
Not bad. Yourself?
Not bad. Interesting morning for you, or was it just state of the art?
Always.
Always.
All right. Your appearance?
Good morning to you and your staff, Your Honor. Attorney Maxwell, DMP number 86012. And Mr. Carlos, who stands to my right, he states your full name from the judge.
Tyler Chad Carlos.
All right. So you negotiated this. You want to make a record of this?
I'll be very brief here. Yes, I've had ample time to speak to the prosecutor, Mr. Mayor, and my client. He does understand his rights and the plea agreement, that plea agreement being a dismissal of the original count in the civil infraction ticket. My client would plead guilty to an added count of operating while visibly impaired. He does wish to avail himself to that offer here today.
Is that what you want to do, Mr. Carlos?
It is.
If you plead guilty to operating while impaired, the prosecutor is going to dismiss the speeding. By the way, drunk or no drunk, you can't drive like that. That's crazy.
I understand that.
And the OWI will be dismissed in the speeding. If you plead on the operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours. Community service, court costs are all those 4 points, license suspension or revocation in accordance with your record. Your vehicle could be, or might have to be immobilized depending upon your record. You understand that?
I do.
And did you sign, read, and understand it, and vote the rights form here today?
I did.
You plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
I do.
To the charge operating while impaired, how do you plead?
Guilty.
On February 7 of 26, were you operating a motor vehicle on Jefferson near Gibraltar at 10:12 p.m.?
I was.
Did you drink alcohol prior to that? And what did you drink?
I did. I had about 5 vodka lemonades at Rivertown.
Okay, and was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
It was.
You think you were driving 82 and a 45 because of the alcohol you'd consumed?
No, I don't.
You always drive 82 and a 45?
No, I don't.
Well, then why was your,
I turned right off of Breland right there, and the bar is right there. You know what I mean? So that's why I kind of picked up the speed because there's cars coming, and it's tough to see. So yes, I do believe it was probably to do with the alcohol, but it was also just because I didn't want to pull into oncoming traffic all of a sudden.
82 on West Jefferson?
I know, and I'm from Trenton. I know how West Jefferson is.
All right, ultimately you were arrested and transported to the police station, right?
Yes.
Was this an intoxilizer, Mr. Dubin?
It was, I believe, it was, let me be sure.
You were
I just
administered.
want to make sure it wasn't a data master or a toxilizer. Yeah, it was a toxilizer 9,000, Your Honor, and the PAC of that would be 0.159, and the defense was stipulated to that.
Are you on probation or parole, Mr. Carlos?
I am not.
Anybody forced you to plead guilty?
No.
Plea is accepted to impaired driving. I find it to be an inaccurate plea. The OWI is dismissed. The speeding's dismissed. I'm going to refer you for screening and assessment. You'll be screened and assessed today. You'll come back for sentence. So the screening and assessment will take place today. You're going to go down the hall. We're going to give you a notice. What do you have for me, Heather?
May 21st at 8:30.
Is that good with you, Mr. Dubin?
Let's do it, Your Honor.
May 21st at 8:30, okay?
Okay.
So you'll go down the hall, we'll give you a paper notice, then you can go over across the hall where you'll fill out a questionnaire and be interviewed. You and your lawyer will have a chance to look at the report, okay?
Thank
When
you.
you come back. Have a great day. You have another one, counsel?
Yeah, you're to talk with me.
That's all right, Zaven.
Good for you.
That's okay. Zaven Perez, 26G306838A and B.
Good morning, Your Honor, to you and your staff, Jerry Maxwell, Freeman, P number 8601, Mr. Perez, who stands to my right. Please state your full name for the judge.
All right, so this will be a plea to impaired, correct?
This will be pleading to impaired, Your Honor. They have time to discuss this matter with the prosecutor, and my client doesn't wish to avail himself to that offer being dismissal of all the original counts. My client will plead guilty to an added count of not payment. Or is it amended? I'm sorry, I might have messed that up for you.
No, he didn't, oh, yes. So he's going to dismiss the PBT refusal.
Yeah, and dismissal
Of the OWI, right? The default judgment set aside. If you plead guilty to operating while impaired, the operating while intoxicated will be dismissed, and then ultimately I will set aside the default on the impaired on the PBT refusal, and that will be dismissed pursuant to stipulation. Do you understand that?
Yes, sir.
Do you agree to that?
Yes, sir.
If you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension and revocation, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
Did you sign an advice of rights today and read it and understand it?
I don't believe so. I was.
You did, the sheet that you signed upon the rights.
Oh, okay. Then yes, I didn't.
All right. You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. By pleading guilty, you're giving up your right to remain silent. You're giving up your right to a trial. You're giving up your constitutional right to a jury trial. You're giving up your right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and you're waiving the presumption of innocence and the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
To the charge operating while visibly impaired, how do you plead?
Guilty, sir.
On February 7th of 26, were you operating a motor vehicle in Middle Gibraltar near North Gibraltar in Gibraltar at roughly 2:03 in the morning?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Repeat that, I'm sorry.
What did you have to drink alcohol wise and how much?
Yeah, I had alcohol. I probably had about 4 drinks,
What kind?
Jack and Coke.
What else?
That's about it.
Was your ability to operate the motor vehicle impaired because of the alcohol consumption?
Yes, sir.
In what way? Why were you pulled over by the police?
I was pulled over because I was going 40 and a 30, but honestly, I thought the speed limit was 40. There's like literally no lights there in the street where I was at, and I just assumed that it was 40. So that's why I got pulled over.
Where were you drinking at?
I went to River Villas.
Okay. And then ultimately you were arrested and transported to the police station.
5 minutes from my house. Yeah.
And Well, where do you live? I thought you lived in Dearborn.
No,
Heights.
I live in Brownstown,
What's your address?
20290 Indiana Avenue.
Okay. All right, so then. You were ultimately administered a blood test, correct?
Yes, sir. I was just looking for a blood test.
And were the results 0.152, Mr. Dubin, you
Yeah.
stipulate that was accurate?
We stipulate the accuracy of the blood.
Are you on probation or parole?
I'm not.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No, sir.
Plea is accepted to operating while impaired. The OWI and PBT refusal are dismissed. I'm referring you for a screening and assessment, and we could do these again, May the 21st, I guess, at 8:30.
Not May 22nd like the other, Your Honor?
That was the 20, no, we set it on the 21st on the,
Oh, did I screw up? I'm so sorry.
no, it's the 21st. Are you good on that?
Yeah, absolutely. Yeah.
So, right, Heather, we can do another one on
Yeah.
that date.
That's correct, Judge.
So May 21st, 2 weeks from today at 8:30. So you're gonna go down the hall, get your paper notice, go over to probation, fill out your questionnaire and be interviewed, okay? Do you understand everything?
Yes, sir.
And again, just to be clear, I'm dismissing the PBT refusal. Wish you well. Good luck. Have a good day, Mr. Dubin.
Thank you, Your Honor. Great to see you guys.
Take care.
Such a
Take
great
care.
weekend if I don't see you.
Thanks a lot. You too. We're gonna run you for Congress someday, Mr. Dubin.
I don't know if you guys want to do that.
Court does call the case People versus Aaliyah Benton.
Horrible for everything.
Good morning, Your Honor. James Fifelski on behalf of Ms. Benton, who is coming out soon. Please state your name for the judge.
Aaliyah Benson.
All right. Your Honor, this is a new file. I'm asking the court to adjourn for discovery.
Probable cause conference will be adjourned to May 21st, 2026, 9 a.m. Bond continued.
So,
Thank you. Oh, right.
Just is present. Today, I'm requesting that the defendant sign some documents as it relates to the current care for her children. So I'm just requesting that the defense counsel review those with her and see if she will sign them, or I will ask or it will be, I hope that will be necessary.
Your Honor, I do have the documents. I don't have a problem discussing those with her. All right. And so I do plan to do that. I did fail to request if I could very briefly address bond. 30 seconds tops.
Go ahead.
Your Honor, she has a $250,000 bond at this point. Her only prior conviction, I believe, is an impaired. She's on bond on a violation of probation with Judge Barr. 5 kids she does need to financially provide for who are under the care of CPS, and there is a family safety plan. I'm just asking that you grant her house arrest so that she can at least work, provide for her children while these cases are pending.
Respond.
So I'm going to check. Bond at this time, this case involves the shooting the butt of a 4-year-old, the defendant's 4-year-old by her boyfriend, I believe, who has not been found. The defendant did transport the child to the hospital and then proceeded to lie to police about what happened and then tried to leave the hospital without seeing it. So I have concerns that he has a flight risk and danger. Given that we don't currently know the whereabouts of will be for co-defendant, I have additional concerns that she will try to get in touch with him.
Anything else?
GPS tether would help keep track, for Your Honor.
Motion for bond reductions denied. Bond will continue.
All right, thank you. I'll be back. Going on. Thanks.
Court calls the case People versus David Grayson.
People.
Stephanie Cannon on behalf of Mr. Grayson.
Your Honor, he just texted me. He told me he had your Zoom information. But I retexted it to him because he says I don't have the Zoom information. So I just sent it to him like 30 seconds ago. So he is trying to Zoom in. Yes.
So what do you want me to do? Wait?
Well, I would like for you to maybe move it towards the
Bellinger said no.
could. And I would still ask you to do it though.
What? Of his? Yeah, well, he has more.
He does, Your Honor. A new charge was issued against him on 4/22.
Was he arraigned on it, do you know?
He has not been arraigned as of yet. I let him know about it yesterday.
Okay,
I'll try and get it.
fine, I'll pass it.
Thank you, Your Honor.
Court calls the case, People versus Jamie Gurney. What is, are those just interns packed over in the corner?
I believe so, Your Honor.
Oh. Nobody put the baby in it. Go ahead. What?
Good morning, Your Honor. This is Plug Defender Davi Leave on behalf of Ms. Gurney. Ms. Gurney is standing to my right. Ms. Gurney, could you tell the judge her name?
Jamie Gurney.
And Your Honor, we'd like to set this matter for preliminary examination, please, and discovery is complete.
Discovery is complete?
Yes, Your Honor.
Right. And would people have their witnesses available the 19th?
We will try for that date, Your Honor.
All right.
Thank you.
Preliminary examination, May 19th in person, 9 a.m. before Judge Garwood.
Thank you.
All right. Thank you. Court calls the case, People versus James Heron.
And Public Defender Chelsea Ridgefield with and on behalf of Jake. Oops.
Thanks, Heron.
And I'm asking to adjourn this one as well for a plea discussion.
Probable cause conference, May 28th, 2026, 9 a.m. Bond continued. All right. Thank you, Chip. Thanks a lot.
I'll walk out.
You're doing those waivers. Okay, can you just double check those? Aye. Court calls the case of the People versus Hosea Hill.
Thank you, Your Honor. Alex Warren on behalf of Mr. Hill. Mr. Hill, can you state the court?
Hosea Raphael Hill. Good morning.
Good morning. We're going to need to deal with this violation.
Your Honor, I reviewed that with my client. At this time, he's going to admit to not only his behavior towards.
Why was he acting that way? You're going to have to give me an explanation for that. Those folks over there at Community Corrections have to deal with a lot of people coming through, a lot of people that are under stress, and they don't need this garbage. Certainly, and I'll be honest with you, especially Ms. Dozier, does not need this garbage. So before you start talking to me, you better make sure you understand what you're saying to me.
And Honor, before the violation issued, right after the intake terminated because of behavior at the intake, Mr. Hill came to my office.
We're clear. It's not just his behavior. She had to call officers in, try to deal with it, and still tried to do it, and he still didn't do it, and he didn't complete his intake. Go ahead.
My office made me aware of what happened. Sat down with me, wrote an apology letter to Agent Dozier, sent to her. I extended my apologies on his behalf. And I think to try and put this into context, and he acknowledges there's no excuse for it, but to try and put it into context, Mr. Hill has had medication stolen. He's prescribed medication for a mental health diagnosis. As he scheduled 2 appointments with his psychiatrist to make a plan moving forward. And after sending our apology letter to Agent Dozier, one thing Dr. Hill brought up was if his social worker was present at the time of intake, I think that might help him regulate his emotions, but he's still trying to get back on the medication that he's prescribed. So
Let me just read the letter here.
well, Your Honor, I can answer any of the court's questions, and I think Mr. Hill can answer any of the court's questions as well at this time.
Please, I will answer. Please. Thank you. This is difficult. It's very difficult what's going on. But please, I will answer whatever you need to know from me. Over here. I did not expect to go to that meeting and that happened. That's for sure. I'll be open. I'm an open person. And I was just opening up to Miss Dozier about my.
No, you weren't. You were interfering with the intake process. She was just trying to get certain things done.
Can I mention something?
Go ahead.
I was talking to Miss Dozier in a meeting, and there was some confusion. I was confused, and I was explaining to her why. Because the magistrate informed me that if I go to when I go to community corrections, because he ordered me to go to, and I did everything he told me to do. And when we were in court, when I was in jail, and we were in court, he mentioned about corrections, and I already had past experience with community corrections, so I understand that these things cost money. And excuse me, please, I'm not interrupting anyone, and I don't do that. So if I do, sorry. But once I was ordered to go there, I mentioned the judge in court. I said, Judge, I do not have any money. I just do not have any money, Judge. And he said, that's okay. Community corrections will not turn you away if you do not have any money. So when I went to community corrections and met with her in her office, I mentioned that to her. Because she mentioned that, I asked her, is this going to cost me? And she said, yes. And I said, okay, well, I don't have any money. And she mentioned that excuse me, I'm trying to talk, sir. I am trying to talk to you.
Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoked. Adjourn next week. Take him.
Your Honor, we can come back next week on that.
Yes.
I appreciate that.
Oh, you better keep moving. I'll adjourn this out to the 14th.
Appreciate that, Your Honor.
Here's what I'm going to do, because I think they're going to devote all their resources there, and I don't have everybody in here. Court's going to stay in recess.
All rise.
Bellinger, you got any more like that? No, never mind. Huh? Yeah, I think you had something to do with it. Okay, I'm doing an investigation. Court does call the case, People versus Deborah Collette.
Bellinger, Assistant Public Defender, on behalf of Ms. Collette, who appears via Zoom from the jail. Ms. Collette, can you please state your name for the record?
Deborah Joanne Collette.
Your Honor, if we may briefly approach on this.
Yes, you may.
Thank you.
All right, on this matter, I will adjourn this out, given rationale to June 4th, 2026, 9 a.m. Also, with regard to defendant's bond, without stating everything on the record, I don't think it's necessary. The court is going to reinstate the defendant's previous bond with the scram tether.
May I name the record, Your Honor?
May.
Thank you. And at the bench, we did discuss this case briefly. I did indicate that I understand the court's decision, but for the record, the people were not willing to stipulate to any change in bond. We just mentioned the defendant was on scram tether and did show that she was looking on that tether, and this is an OWI under defense. Thank you, Your Honor.
Yes, that's right. All right. Ms. Collette, I'm going to give you another shot.
Thank you.
All right. Don't mess it up. Because there's going to, if you drink again while you're on that scram tether, there's going to be nothing Mr. Bellinger can say to me that's going to change my mind. You'll just sit. You understand that?
Yes, sir.
All right.
I do think she was going to admit as well on the record.
Yes, that's going to admit to the violation. Is that correct, ma'am?
Ms. Collette, do you admit to the violation?
Yes, Your Honor. Yes.
All right. How long has she been in?
She's been, I believe this is her 6th day, Your Honor.
Defendant having admitted to the violation, I'll sentence and it's 6 days. Washtenaw County Jail, credit 6 served.
Thank you.
I'll reinstate the defendant's previous bond with the scram tether prior to her release.
Understood. Thank you.
All right. Thank you.
Thank you.
I moved it out to June 4th so they can get the sobriety court stuff.
Thank you.
Thank you. Court calls the case, People versus Devin Gibson.
Is that on behalf of Your Honor?
Morning, Your Honor. Sam Bernstein with NAMI.
Gibson, state your name.
Devin Gibson.
Thank you.
Your Honor, asking the court to please set this for exam. Discovery is complete.
All right. People have their witnesses available the 19th. Preliminary examination, May 19th, 2026, 9 a.m. before me.
Thank you, Your Honor.
All right, thank you. Court calls case, People versus David Grayson.
And Mrs. Grayson, hearing by moving. Your Honor, wasn't he?
Of course. Your Honor, I don't know.
Yes.
He was there. He had the old Zoom information. I gave him the new Zoom information. He came in. There was a kerfuffle, and then
A what? A kerfuffle? What is that? Find that. I don't know big words.
That's just I don't know. Said it dropped on him, and he was supposed to log back in. Is what he said.
Oh, when was that?
I don't know.
Don't text him now. Would you?
When I checked, he was in there. I looked. I made sure. Then and now we're here. I'm going to ask for a 1 week adjournment, Your Honor.
No.
He was here. Okay.
Is there PDs in the next block or no?
Yes, I'm here all over the place.
Quit threatening me. What? There are? That starts at 12:30? So you got an hour and a half.
I'm going to say he moved you to 12:30. Be there or be in jail.
Should I make him come down here?
So here's the deal on that. Listen, so I'm going to go with no, because his sister has to be the one that drives him in. And that's where the problem came in. I'm sorry, not his sister, the mother of his child. That's how come he couldn't get here in person today.
Not the same person.
I recognize that.
Okay.
Hopefully they are not the same.
Okay, I don't know. Just saying.
So he does not have a ride today. So please, if you're going to do
Shannon.
Yes, Judge.
If I get him in Zoom by 12:30.
Yep.
Please have him have a stable connection. I'm doing this only because Ms. Fields.
Thank you. Thank you, Chelsea. Thank you.
Court does call the case, People versus Lawrence Buckner.
And on behalf of the people, Your Honor.
Your Honor, my client just stepped out in the hall. I'm just having.
Yeah.
Chris Crowder, I'll be behalf of Mr. Buckner.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Buckner, who approaches.
Your name?
Say your name.
Lawrence of the family of Buckner.
Your approach.
You may. All right, record should reflect an events conference in this case. Starting with the case ending in 0446, there's been an amended complaint filed. Counsel has indicated
Yeah, we will waive a formal reading stand mute tonight, Your Honor.
then in this matter, it will adjourn it. So it will adjourn both cases out to the 21st, May 21st, 2026, 9 a.m. At this moment, sound will continue. Mr. Buckner, sir. I've gotten a report, and there are some reports that you were in the vicinity of the victim in this case. All right. Sounds to me like it may have been that you were there. She may have showed up in the area or whatever. I'm not attributing any ill will to that. I'm just going to inform you that you happen to get up. You're required to leave. Okay. Be in that area. Am I understood?
I was at work.
Just say yes.
Okay, is it outside of the work? Is it outside of work, Mr. Simpson? Because I honestly,
Mr. Buckner,
yes,
because you don't
I understand.
don't shoot
Yes.
yourself in the foot right now. Just giving you. Say yes.
I said, I understand that, but I'm asking about work. Mr. Simpson, is it also include work?
I have two ways that I can handle this. All right. I am not handling it in a way that is the most harsh. I told counsel that I would give you that admonishment. All right. There's a circumstance where you're legitimately there. Talk to your attorney about that. Okay. And they will be able to advise you what you should do in those circumstances. I am giving you my warning. Right? Am I understood, sir?
I heard exactly what you said. So you told me to ask my counsel if I have any questions in regards to being justified at any location.
Stop there.
That's what he asked me. I'm just showing I was listening.
Just say you understand.
Yes, yes.
Right. Thank you.
All right.
Okay. All right. What else?
That's it.
Oh, I didn't know if I was dismissed yet. Thank you.
You will let him know I could have handled that very differently.
Oh.
Courthouse case people versus Lewis McSwain.
Ask all the paper.
Trovius Starr, standing in for the attorney of record, Mr. William Amadeo, on behalf of Mr. McSwain. Mr. McSwain, state your name.
Lewis McSwain.
Get hands out here.
Your Honor, two things here. First, Mr. Amadeo has informed me that he has not received discovery yet, so he's asking for an adjournment. And then secondly, it's my understanding that there's a community corrections violation for positive for opioids.
And cocaine.
And cocaine. Okay.
So that you know, there's on April 10th, he was positive for cocaine and opiates.
That's when I first got out.
On the 17th, a week later, there's no drugs found, but he has diluted his creatinine. So he watered the test and it comes back with diluted creatinine levels. But then by the 23rd, about 6 days later, the opiates are back.
That's correct, Your Honor. I think that the 10th, the defendant had just gotten out of jail after being arrested. So there was nothing to indicate that abuse may have been while he was on bond. However, the court is evidence of the correct of 17th dilute creatinine as well as the 23rd with the positive opiates. I am aware that there's a prescription that Mr. Starr showed me for hydrocodone that's prescribed to the defendant. However, the date of that prescription that I saw on there, and maybe there's a new one, April 29th,
April 29th of
2026.
Your Honor, if I may, my client Mr. Amadeo's client has informed me that he's been receiving the script, if I could approach, for 2 months now. And he can go back and show prior scripts. May I approach?
Yeah.
There's 3 different prescriptions on there.
Okay, I see that, but
the last one is for
this is from the 29th.
Correct. He informed me that he can go back and get those prior scripts. A letter from his doctor as well to show that he's been receiving this now for 2 months. So the
he's getting them filled at Walgreens.
I'm sorry, what was the question?
Does he always get them filled at Walgreens?
Filled at Walgreens. Other places.
There's other places. A little closer.
It varies in terms of the
place he picks up his prescription. But he can get a letter from his doctor stating the initial date that he was prescribed hydrocodone.
Well, I think somebody better go find that because all I have in front of me is a positive test and a prescription after that date. I don't have anything on these indicating.
I didn't have no way when I got out. I had already been taking them, so I don't know where to keep this.
And it's interesting also to me that, well, let's see, make sure I'm saying this right, which would be typical that these aren't refills.
I also just think I noticed that, Your Honor.
So,
And it would be the request of the people just to make the record clear that the defendant be remanded at this point and his bond be revoked. This is his third test that he's given. And the two that would have been when he was on bond, neither of them are acceptable or negative. It's also my understanding when someone does an intake with community corrections, they're understanding these corrections. They understand that people may prescribe things that will come up on their test. And I don't have an indication of denial. One time, you let me know that the defendant had that conversation with community corrections. It's oftentimes the case that they will say to the effect of, we are aware this person is prescribed buprenorphine. We're aware that they're prescribed any variety of things that may be positive on the test. The court in this case, I don't know if you've had an opportunity to review the charging documents, but this is a delivery and manufacture case. Okay, so this is a case where we have somebody that's manufacturing or delivering controlled substances, and he's now testing positive for opiates. I'm extremely concerned and would request that bond be revoked, he be remanded.
Your Honor, I'm asking at this time, just for right now, that you not do that. If you could allow me some time to possibly get in contact with his doctor so we can get this squared away. He has a prescription for hydrocodone. That's there. He's informed me.
Prescription, though, is after the date of actually both of these. Actually, the first test and it's after the date of all of his testing.
Yes, the prescription that we have right now. That's why I'm asking right now, just for this moment, right now, if you not do that to allow me to clear this all up. I was just informed about this. It's not my case.
So let me ask this.
And also, too, one more thing. He does not.
Okay, go ahead. Interrupt me.
Okay, I'm sorry.
No, go ahead. What do you want to say?
My client has informed me that he does not have a supervisor, an agent at community corrections.
I was trying to bring him there and tell him because the warrant came out after I had.
What do you mean he doesn't have one?
He has no one that he goes and speaks with directly.
Pay my money and
you can speak up. You can speak up.
I just paid my money and drop. Like, I was trying to bring it to anybody's attention, but they said they don't have nobody.
So I'm asking if you could pass this matter and allow me to.
Here's my question. Why does he have these today?
Because he's been trying to inform people that, hey, I'm taking these medications, and which one of them is an opioid. So he brought it to court. He did this instead of leaving it at home. He did the smart thing and brought it with him. Instead of
knew he had a positive test.
Yes, because he's been taking opioids, and that's the part where I'm asking if we can pause this matter so I can look further into this, so I can shell this out.
What does Bellinger want to say?
Your Honor, I would so too ask that this matter get passed for a few moments. I do have some information that I can share with the attorney that may or may not be helpful to at least past use of Norcos with the client.
I'm just asking if we can pass this matter for right now. I'm not even asking,
I want to know. Hey, certainly, Mr. Bellinger, I'll let you talk with counsel, but I'm trying to figure out why did he bring these today and not the previous ones?
It's been my experience, Your Honor. Been doing this now for 11 years. I've come. Yes. Wow. Congratulations, Tro. Yeah.
11 years.
I've come across plenty of clients who say, "Oh, I have
for the time that's like 1/20th of the time Vincent's.
I have a prescription," and then I asked, "Where's the prescription?" "Oh, I left it at home." He brought it with him. He's been trying to get someone to see, "Hey, I have a prescription for these things." He hasn't been able to see anyone at community corrections to show them.
Where's the previous prescription?
That's why I want to look into. That's why I'm saying if we can pass this.
Right. What I'm trying to figure out is why he didn't bring that one, because this one is problematic because it's all after his testing.
No, I don't know. Oh, you knew. They tell they called, but I'm saying for the prior one, I don't. But then it wasn't on any papers about it.
Your Honor,
and none of the
answer your question.
Cocaine. But anyway, go ahead.
But that was, I believe, when he got released. But to answer your question, why did he bring this? Community corrections and called them and informed them, "Hey, positive test." So he brought that. He brought the current prescription. Again, I've come across plenty of clients who say, "Oh, I have a prescription. Where is it? I left it at home. I can't find it." He brought something. I'm asking, based off of that something, if I can go and look further into it just for right now. Just for right now.
For how long?
10, 15 minutes.
Okay, then at this point, his bond's revoked. They can take him, and then we'll bring him back out if necessary.
Mayor, post.
If you want to, but I don't know if you do.
Previous prescription. I didn't have to keep because there wasn't a warrant out for my arrest for this case. So I had no reason to keep it. I wasn't reporting to anybody. So when the warrant came out, that's when I was, you know what I mean? And now I got to start keeping them. But prior to that, I never had a warrant, so I never had to keep them.
Oh, okay. All right. Thank you. Court calls the case versus Christopher Proby.
Stephanie Cannon, on behalf of Mr. Proby, who's appearing as biased. Can you please state your name for the record?
Christopher Proby.
Thank you.
Your Honor, we are asking for an adjournment of this matter.
Of course you are. No, go ahead.
Actually close to a potential deal. I'll run some things past my client that was discussed today. In addition, we have stipulated to allow him to travel this weekend to Ohio. Vacation to Cedar Point. It's May, Judge. May showers, June flowers. I don't know.
Yeah,
To Cedar Point anymore. Everything makes me sick. So I'm living vicariously through my client.
Is it? Fine. I guess.
Thank you so much, Your Honor.
And probable cause conference, I'll adjourn it to May 21st, 2026, 9 a.m.
Thank you so much.
All right. Have fun. Don't get
Your Honor.
You're all right.
I won't. I'll behave.
Court calls the case. People versus Francisco Quezada Laureta. Court calls the case. People versus Lawrence Ransom.
Your Honor, reading the code for the people.
Your name, sir?
Lawrence Ransom.
All right. So we at least know you're here.
Court have a green sheet in this file?
What?
Does the court have a green sheet?
No.
Your Honor, I am happy to fill out a green sheet.
You know what? Joy Gaines is much better at stalling than you are.
Oh.
But you've accomplished the task. Here she is.
Public Defender Chelsea Virgils with and on behalf of Florence Ransom. I apologize, Your Honor.
No, it's okay.
Um,
He and I were having a great.
I have a green sheet. I'm asking to adjourn this. Sorry. I know I'm not normally this disorganized. Apologize.
No, it's okay. All right.
Ransom, we're looking for a sobriety court for him in
Okay.
Wayne County. We currently haven't found any that are taking, but we want to continue working on it. And I submitted
You reside in Canton, correct?
I submitted a STIP to the court as well to allow travel
Okay. Allow travel.
from May 19th to 24th to attend a graduation in Georgia.
Everybody's going to Georgia for graduation. I think everybody's graduating in this whole state.
All right. So he wants to go the night you sent that in on paper.
I did.
Okay. I don't have it in front of me, but okay. And that's the 19th through the 24th?
Yes, Your Honor.
Okay, well, I want to set it then. And you're trying to find a sobriety. Okay. I know that takes some doing, but are you on a tether?
Yes.
Okay, good enough. I'll set this to June 4th. (2026) at 9. And how far are you in the process? I mean, if he wants to go into a sobriety court in terms of trying to find one.
We've reached out to a few. The ones we've reached out to have said no. So just in the process of reaching out to more, seeing if they're accepting any transfers.
Not at all. Well, I'm going to make it June 11th. Try to give them more time to see if they can find something for you. Okay, sir. Fine, continue.
Thank you, Your Honor.
All right. Thank you. Travel safely. Or not. Court calls the case, People versus Raymond Strausser. Wait a minute.
The public defender leaves out on behalf of Mr. Strausser. Approaching.
Yeah.
Have yours. I overestimated my strength.
Good afternoon, Your Honor.
Good afternoon.
My name is Raymond Strasser.
Thank you. I have before me a plea form that indicates that the defendant will be pleading guilty to 2 charges. He added count 3 of use of methamphetamine, and it added count 4 of use of cocaine.
Yes, sir.
Those are both punishable by up to a year. Upon a successful plea to those charges, counts 1 and 2 would be dismissed. Defendant is also agreeing to enter into and participate in Veterans Treatment Court. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Yes, Your Honor.
May I have him sworn?
Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do. Raymond Strasser.
All right. Third, this is court's understanding that you're going to be pleading guilty to 2 charges. First charge is the added count 3 of use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. You understand that, sir?
Yes, I do, sir.
And also an added count 4 of use of cocaine. That's also a misdemeanor punishable by up to 1 year, $2,000 fine plus court costs. You understand that?
Yes, I do, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District.
Okay.
You understand that?
Yes, sir, I do.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, I do.
All right. To the charge of use of methamphetamine, how do you plead?
Guilty.
To the charge of use of cocaine, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Understand that.
You signed an advice of rights form, is that correct?
Right.
Any questions regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily and of your own free will?
Oh, yeah.
And also because you believe that you're guilty of these offenses?
Yes, I will.
All right. On the date of April 3rd, 2025, at the location of 410 West Huron Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have methamphetamine or ecstasy in your possession?
Yes, sir.
All right. And you also had cocaine in your possession?
Yes, I did.
Had you used both of those?
I hadn't used methamphetamine because I had just purchased it. But I did use the cocaine, but the day before I had some amphetamine.
Okay, so right around that same time, you did use the methamphetamine. All right. And you had used the cocaine.
Yes.
You at the time that you were using that, you knew that you were using methamphetamine.
Yes, I did.
And when you were using the cocaine, you knew you were using cocaine.
Yeah.
All right. Sir, I do have to apprise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
I do understand that.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes.
Court will accept the defendant's pleas of guilty. 2 counts 3 and 4, counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
May 26th at 9 p.m.
May 26, 2026, 9 a.m. That is before Judge Garwood.
I'm sorry, Your Honor. He can actually be sentenced on the 13th. The PSI, everything's already ready. He's come to Veterans Court many times. I'm responsible for that court, but he's
Send us anything today. And they didn't send us anything from the Veterans Court indicating. So you say the 13th is going to happen? All
I
right.
promise. I give you my word. And I'm the one there, so I'll get in trouble
Not
for
to
it.
worry about it. If you're telling me it's a
Ready.
I'm going to go with what you tell me. So I'm going to make it May 13, 2026, 9 a.m. before Judge Garwood. All right, sir?
Yes, sir.
What branch?
Army.
Army. How long?
Almost 3 years.
Almost
A little over 2.5 years.
2.5 years. All right.
Let
Well,
us out early because Vietnam ended.
pardon?
They let us out early because Vietnam ended.
Ended. Well, often some blessings, right?
Yep.
All righty, sir. Thank you very much for your service.
Thank you.
Here. Court calls case, People versus Justin Thomas.
Bring it over for the people here.
Brian Bowling on behalf of Mr. Thomas, Judge, who is approaching. State your name for the record, please, Justin.
Justin Thomas.
Judge, when it comes to the pretrial, or excuse me, the probable cause conference, I'm asking that we adjourn that. I'm still trying to get some discovery video specifically. And then I'm prepared to address what you're holding in your hands.
Yes, go ahead and address that.
All right. So he didn't report for the sober link until today. He has it currently right now. He went over to community corrections before coming here. The reason for him not having it before was that he was unable to pay for the shipping costs to have it sent to him directly. He has no resources financially at this point in time, Your Honor. But he does have it now. He lives in Pinckney.
St. Clair Shores.
Oh, I'm sorry. I thought I've been addressing Pinckney. All right. He lives in St. Clair Shores. I'll have to get an updated mailing address for you.
Well, then he needed
So it's even better, I guess, but for my
Right, but he needed to find a way down here. He doesn't get to.
And Mr. Thomas and I had that discussion, Your Honor, that
He's been released and almost for a week. He
did not have transportation to get here, Your Honor. It
could have walked by that time.
It was a very difficult situation getting him here today once the Zoom grant was revoked. But he did make it here today. He has the sober link. He did test at community corrections today. To my understanding, that was negative. And he's prepared to comply with this court's bond order for purposes of testing moving forward, Your Honor.
Well, it can't work. This wasn't even just an issue of not having the shipping. He wasn't calling people back. He wasn't completing his whole intake.
We did complete, my knowledge, Your Honor. He wasn't returning calls. Again, like I said, Mr. Thomas and I discussed that.
I don't expect the court to have any further problems with him at this point in time. He does have the device. He's holding it here. You got to return calls when people.
Why weren't you calling them back? I mean, I don't understand this.
He works nights, Your Honor. I think when he was trying to make the return calls, there was times where community corrections was closed. Again, that's something we discussed. There is a bit of a, may we approach briefly?
May.
All right, thank you. Thanks for the bench conference, Your Honor. I have nothing further to add on the record at this point in time. Like I said, based on him having the sober link now, I would ask the court to continue his bond and then new probable cause conference date, or will be so willing.
Probable cause conference will be set for May 21st, 2026, 9 a.m. At this point, since he's on it, I'm not going to do anything. But I want you to understand something, young man. If you miss one blow, I'm not hearing any other excuses from you.
Oh, no.
Am I clear?
Yeah, you're clear.
Bond will continue.
Thank you, Judge.
Court calls case people versus Ashley Treat.
That's people.
And Lori Yaki, Assistant Public Defender, with and on behalf of Ms. Three, who's approaching. Ms. Three, could you state your name for the court?
Absolutely.
So, Your Honor, within the last couple days, Ms. Three has sought an assessment for treatment. She completed the assessment. I have the paperwork here. I have the letter here. Based on the assessment, she's been recommended to participate in the intensive outpatient program through Henry Ford Health. Again, I have this documentation here. She is scheduled to attend individual treatment on the 2 days that she's not doing her intensive outpatient program, which is scheduled for 3 days per week. Additionally, Ms. Fleet is doing meetings every single day as a part of her recovery. I would ask, Your Honor, obviously the bond violation is very concerning, is very serious.
Okay, yeah, go ahead. I'll listen to everything, but
I would ask if the court would consider converting her sober link to a scram tether to ensure that she's getting 24/7 supervision monitoring to ensure she's not drinking.
Jackie, you do realize that not only did she blow numbers, but then decided to have someone else blow into the machine for her.
Yes, Your Honor. There's no minimizing. There's no excuse or justification. The only thing I can do is present our plan moving forward, which the therapist has a psychiatrist. She does have mental health diagnoses. So she does need medication. She has her psychiatrist she's working with. She has her therapist she's working with. It took her a minute to find the right treatment to address the needs that she has. She is a single parent of 2 kids. They do rely on her tremendously. One is 3, one is 13, I believe. And
So even worse, she had a 13-year-old blow into the machine.
Well,
I didn't ask her to. He's free.
Oh, whoa. Is that what happened?
I didn't.
Be careful how you answer it. I don't know that there's a good answer, but you better be careful how you answer it. Because I don't know which is worse. You telling me that, yes, is that what I did, or you lying to me?
I at this time, Your Honor, I'm asking if the court would convert her to a scram tether and mandate that she
drank and then had a child blow into the sober lane.
I understand that's what the violation report says, Your Honor. And
does she admit to that violation or not? I mean, if she wants a hearing, we'll have a hearing.
I understand. May I have a moment to just verify with her, Your Honor?
Yep.
Your Honor, may we briefly approach?
I don't know what good it's gonna do, but you can come on. Record should reflect we've had a bench conference in this case. Just want to say, Michelle.
The only other thing I wanted to request that I forgot to mention at the bench conference is, if the court is inclined to revoke her bond, I would ask if there's any chance the court would allow her to be released to an inpatient treatment program with the Tether, as clearly the root cause of both the underlying case as well as the bond is an issue of substance use. Again, she has dealt with enormous trauma. She's a survivor of domestic violence. She left an abusive relationship where her ex was convicted. And I think in November or shortly before December, which is the alleged defense date here. So there's a lot of circumstances surrounding here. Understandable that the court and the people are concerned for the community, but I would ask that this not be a case just held in jail without the opportunity to get inpatient treatment.
Ms. Valtes.
Your Honor, the people at this time would request the court revoke the defendant's bond and do not grant her a release to treatment. The underlying offense in this case is not operating while intoxicated. Their defense. Her priors are from 2011 and 2016. In this case, there was more than one call to the police reporting the defendant's bad driving behavior. She was eventually located by Michigan State Police troopers, crashed, and when they had contact with her, she admitted to drinking. Eventually, a search warrant was obtained for her blood, and she was found to have a blood alcohol content, of 0.258. She was incredibly intoxicating, putting the community at risk, and is now drinking on bond. And as the court correctly pointed out, having a 13-year-old child flow into that silver lake. I do not think she is in a position where she is capable of making good decisions. And I do not think that she is a risk the community can tolerate. I'm asking both the bond, hold her without bond, deny her a release.
Anything else, Ms. Carter?
Your Honor, the only other thing I would say is I do think it would be adequate to protect the community if she's not driving, if she has a scram, if she's in treatment, especially if she can't leave.
I can't trust her. I'm just going to be upfront. It is going to be very hard for me to trust somebody that this court releases on a sober link, can't comply with the sober link, drinks, and then to try to save herself because she knows she has to do the confirmation below. She puts a child to do that. Incredible. I will adjourn our probable cause conference May 14, 2026, 9 a.m. I'll also adjourn, since there's no admission or anything regarding the bond violation. I'll adjourn the bond violation hearing to also that date. At this point in time, the defendant's bond is revoked. Defendant's remanded to the Washington County Jail.
Thank you, everybody. Let's have a seat. This is file number 261603FH. The matter is captioned People of the State of Michigan versus Cody Kern. I see Attorney Plumbers is back with us. Welcome back, Mr. Plumbers. Is that Mr. Kern there with you?
Yes, Your Honor.
Gentlemen, would you join me at the podium? While they're on their way to the podium, the court will also introduce Shiawassee County's elected prosecutor, Mr. Scott Kerner. He's present today, too. I was given documents that indicate we're going to attempt a plea. Those documents include a plea agreement sheet signed by the attorneys as well as Mr. Kern, and then a form of advice or rights also appears to have been signed by Mr. Kern. With that, sir, would you raise your right hand? Are you chewing gum?
Yes, sir.
You know what? Just in that tissue right there, would you? I mean, seriously, it's court. Let's try it again. Would you raise your right hand, please? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. You may put your hand down. Mr. Kerner, are you on probation or parole in this court or any other court?
No, sir.
Other than the charges that bring us together today, do you have charges pending anywhere else?
No, sir.
You don't. Very good. Mr. Kerner, do you have terms for us?
I do, Your Honor. The defendant will plead guilty to count 1, conducting a criminal enterprise
pay restitution to all victims. I know it's substantial. It's over $20,000. We don't have the final amount, but
Are you going to have the final amount by sentence date?
we will, and I believe there's co-defendants, but it's a hefty amount, Your Honor.
Are you estimating about $20,000?
He talked about this defendant coming up with that much about at the time of sentencing, so at least. So.
Well, I'd kind of like to be in the ballpark of what restitution is. At least the ballpark. Mr. Plumbers? Plumbers, I'm sorry.
Yes, Your Honor. If I believe the total restitution was somewhere around $40,000.
Okay.
Which my client would be responsible for half. I have talked to him, and he's willing to make a good faith effort by making a $5,000 to $10,000 payment prior to sentencing, Your Honor.
I see. So 40,000 is what I'm hearing.
I want to be limited to that, but it's at least 40,000, yes.
At least 40,000. Okay, at least we're
getting there.
In the ballpark. Very good then. Continue.
The defendant agrees to pay restitution to all victims that would be joint and several. In turn, the prosecutor agrees to dismiss counts 2 through 10. The estimated sentencing guideline range is 51 months to 85 months.
Thank you. Mr. Plymers, is that your understanding of the plea agreement?
Yes, Your Honor, it is.
Thank you. Mr. Kerner, would you read the count into the record, please?
Yes, Your Honor, it's a lengthy one. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court, informs the court that on the date and location described above, the defendant did, count 1, criminal enterprise conducting. Being a person employed or associated with an enterprise, to wit, Cody Kern, Robert Halleck, and or Threadcare LLC, did knowingly conduct and participate in the affairs of an enterprise directly or indirectly through a pattern of racketeering activity consisting of 2 or more of the following incidents of racketeering, to wit, on or about February 12th, 2025 in Shiawassee County, defendant did commit the following offense for financial gain, to wit, did utter and publish as true a certain false or forged, alter, or counterfeit record, instrument, or other writing with the intent to injure or defraud, knowing said instrument to be false, altered, forged, or counterfeit. Said instrument more fully described as follows. Check number 3913, dated February 9th, 2025, in the amount of $1,400.35, drawn on Lake Trust Credit Union, with the purported payee of Threadcare LLC, made by Tammy Patterson with the endorser of Cody Kern. On or about June 11th, 2024, defendant did commit the following offense for financial gain, to wit, with the intent to defraud or violate the law, to use or attempt to use personal identification information of Tyler DeWaters to obtain a debit or credit card or cards on about October 14th, 2024. Defendant did commit the following offense for financial gain, to wit, did have possession or under control or receive from other person a financial transaction device issued by Navy Federal Credit Union with the intent to use, deliver, circulate, or sell same, or permit, cause, or procure the same to be used, delivered, circulated, or sold, knowing such possession and control or receipt would be without consent of the device holder, contrary to MCL 750157P. I believe that's 2 events that is required under the statute. Your Honor, I can continue reading if you'd like, but I believe that it requires 2, a pattern of.
That's all you think you need?
2 or more, yes.
2 or more. Do you agree, Mr. Plymers?
Yes, Your Honor.
Thank you.
And this is a felony punishable up to 20 years and or $100,000, criminal forfeiture for proceeds, substituted proceeds, and instrumentalities of racketeering listed on attached notification. Court may order court costs, cost of investigation, and cost of prosecution, and against the peace and dignity of the state of Michigan.
Thank you, Mr. Kerner. Mr. Kern, I'd like to go through the terms of the plea with you so that the record reflects you and I both understand what they are. Would that be okay?
Yes, sir.
I'm told you're willing to plead to count 1 of the information, which is criminal enterprises, conducting criminal enterprises, and that's a felony punishable by up to 20 years imprisonment. Is that your understanding?
Yes, sir.
Fines of up to $100,000. And I'm told you're willing to make restitution, which the attorneys believe is somewhere around $40,000. Is that your understanding?
That's correct.
Mr. Kerner estimates your sentencing guidelines on a minimum to be between 51 and 85 months in the Michigan Department of Corrections. Did you hear him say that?
Yes, sir.
Did you hear him use the word estimate when he's discussing your sentencing guidelines?
Yes.
That's important because the court will score the accurate sentencing guidelines as we move closer to your sentence date. My point, Mr. Kern, is that if the court scores the sentencing guidelines, they're different than Mr. Kerner's estimate. Maybe they're higher. Don't know anything about the case really. You wouldn't be able to withdraw your plea on that issue. Do you understand that?
I do understand.
All right. And do you have any questions about the terms of the plea?
No, I don't.
Okay. And is that what you want to do?
Yeah.
Other than what was placed on record here moments ago, Mr. Kern, has anybody made you any promises to get you to plead guilty?
No, sir.
Mr. Plymers, are you aware of any promises not placed on the record?
No, Your Honor.
Thank you. Mr. Kerner?
I'm not.
Thank you. Mr. Kern, has anybody threatened you or any members of your family to get you to plead guilty today?
No, sir.
Are you pleading guilty to criminal enterprises because you are in fact guilty of committing that crime?
Yes, sir.
And has your attorney, Mr. Plymers, today left a final decision as to whether or not to plead guilty with you?
Yes, sir.
Has he talked to you about the different choices that you have to resolve this matter?
Yes, sir.
Has he explained to you that you have a right to a jury trial and all that entails?
Yes, sir.
Have you concluded then, Mr. Kern, that this plea offer made by the people is in your own personal best interest to accept?
Yes, sir.
Do you understand, Mr. Kern, that once the court accepts your plea and finds you guilty, you give up or you waive your automatic right to appellate review? Do you understand that?
I understand.
If you wanted to appeal these proceedings, that's fine, but you'd have to get another court's permission to review or appeal. Do you understand that?
Yes, sir.
Do you have any questions so far?
No, sir.
One of the forms that was given to me of Mr. Plymers moments ago was captioned Advice or Rights. When I look at that form, Mr. Kern, I see a printed name on the bottom. It reads Cody Kern and then a signature above it. Is that your signature?
Yes, sir.
Mr. Kern, did you read all the rights that are on this form before you signed it?
Yes.
Before you signed the Advice or Rights form, did your attorney, Mr. Plymers, did he make himself available to you to answer any questions you might have or address any concerns you may have?
Yes, sir.
All right. And then, just before you signed the Advice or Rights form, did you in your mind knowingly and willingly waive those rights?
Yes, sir.
Do you have any questions of the court regarding your rights?
No, sir.
Do you have any questions of the court regarding anything that touches and concerns the plea?
No, sir.
Are you ready to move forward?
Yes, sir.
Very well then, Mr. Kern, how do you plead to count one, conducting a criminal enterprise?
I plead guilty to criminal enterprise conduct.
Well, let's go back to the time and date set in the information through the dates of June 11th, 2024 and February 12th of the year 2025. Did you have a document that you falsified, altered, or forged?
Yes, sir.
I'm looking at the incident on February 12th of the year 2025. What document was that?
Possibly IDs, social security numbers.
This is a check.
A check. Okay.
Check number 3113, dated February 9th, 2025.
Yes, sir.
Does that sound familiar to you?
Yep.
And did you prepare that document?
Yes, sir.
Did you put information on it that wasn't true?
Yes.
Is that a yes?
Yes.
Did you present that to a bank?
Yes, sir.
And did you want that bank to believe that it was true and genuine?
Yes.
And when you presented that, you wanted to get money from it, correct?
Yes, sir.
And when you wanted to get money for it, when you presented that draft or that check, you knew that it was false, correct?
Correct.
And do you intend to defraud or cheat someone when you made that transaction?
Yes.
And where'd this occur?
Where did this? At my home, in Owasso.
That's in Shiawassee County?
Yes, sir.
And did the same thing happen on June 11th of the year 2024?
Yes.
And that was owned, the first one we just talked about was the payee was a victim with the initials TP, correct?
Yes.
And the second one on June 11th of the year 2024, that was the payee is a victim with the initials TD, correct?
Yes.
And then did you have a draft on that date that you fraudulently prepared?
Yes.
And did you submit that to a bank?
Yes.
And did you want the bank to believe that the document you were giving them was genuine and true,
Yes, sir.
when in fact you knew that it was not?
Yes.
And you wanted the bank to give you money because you wanted to defraud them, correct?
Correct.
And this was, where did this occur?
At my home.
All right. And were you an employee or associated with any of these victims?
Yes, sir.
What was your what was your relationship with these victims?
One of them I was employed with. Another one I went to school with. So I knew him for a long time throughout my life.
So the one you were employed with, you knowingly conducted, you had a pattern of defrauding them. Is that correct?
A pattern. I mean, that's what it looks like. Yeah, as a pattern.
Right? More than once?
Correct.
And then the same with the victim with the initials TD?
Yes, sir.
I believe it was a credit card that he privately obtained for TD.
I see. Okay. So with TD on June 11th of your 2024, it wasn't check. You applied for a credit card using TD's name?
Yes, sir.
And then you got that credit card?
Yes.
And when you made that application to the credit holder, you wanted them to believe that you were TD, but you were not.
Correct.
And you wanted to give them money so you could defraud both the creditor and TD, correct?
Correct. It wasn't a personal vendetta towards.
No, we're just talking about motive. We're just trying to get the elements of the crime.
Okay.
And would you agree that these two instances are a pattern of racketeering?
Yes.
And both the check and the credit card have substantially similar purpose, interrelated, and are not isolated acts. Is that correct?
That's correct.
And do you agree that these acts pose a threat to continued criminal activity?
Continued from here on out, or at that time?
No, at the time.
At the time, yes.
And they did occur after April 1st of the year 1996, correct?
Correct.
Mr. Kerner, do we have a factual basis? And this is a complicated crime.
Yes, sir.
Mr. Kerner?
I believe so, Your Honor.
All right. And did you do this with someone else, like a co-conspirator or a co-defendant, who helped you actively to steal from these people in these businesses?
Yes, sir.
All right. And this person, as far as you know, had the same criminal intent that you did?
Yes, sir.
Okay. Mr. Plymers, do you believe the court has a factual basis?
I do believe so, Your Honor.
Mr. Kerner, thank you. Do you believe the court's complied with the guilty plea provisions of 6.302 subsections B through D of that court rule?
It has.
All right. Mr. Plymers, do you concur with Mr. Kerner on that point?
Yes, Your Honor.
All right. I agree with the lawyers, Mr. Kern. The court does find that, you guilty of conducting a criminal enterprise and finds that your plea is understanding, voluntary, and accurate. You got your calendar with you, Mr. Plymers, or will Mr. Dillon be?
Hold it up right now, Your Honor.
All right. Mr. Richardson, do we have a sentence date?
We do. June 12th, 2026 at 8:30 a.m.
June 12th?
Yes, sir.
You said 8:30, sir?
Yes.
Yes, that works for me, Your Honor.
Very good, then. Make sure that you get a copy of the PSIR, pre-sentence investigation report, a week before. It'll be emailed to you. Come at 8:30. Be ready to discuss any guideline challenges you might have, and make sure you're prepared and ready to go.
Will do, Your Honor. Thank
I know
you.
you will. Would you like to address bond?
Your Honor, I just would ask that my client remain out on bond. He, as you've seen, he's been here today. He was on time. I have been in consistent communication. So I would just ask that he be allowed to remain out on bond until sentencing, Your Honor.
Thank you. Mr. Kerner?
He does have significant guidelines, but I'd leave it at the court's discretion.
Yeah, he does. These are invariably guidelines that could send him to the Michigan Department of Corrections. So let's go ahead and get started on that sentence. You will be remanded to the custody of the Sheriff's Department to await your sentence. A couple of things have to happen when you're at the jail, Mr. Kern. Number one, jail personnel is going to want a DNA sample from you. Please cooperate with that test. Next, An agent from the Michigan Department of Corrections will be along to interview you. It's a really important interview because the agent's going to make a recommendation to the court as to what your sentence should be. So be honest and forthright during that interview process. If there's anything good you want me to know about you, let the agent know. Do you understand?
Yes, sir.
All right, thank you. You can go with the deputy. Thank you, everyone. Let's have a seat. This is file number 261713FH and is captioned People of the State of Michigan versus Courtney Flanner. Are you Miss Flanner? All right, and Attorney Plummer, is it?
It is Plymers, Your Honor.
Plimer?
Plymers.
Plymers.
Yes, sir.
Folks, would you join me at the podium, please? Mr. Plymers and Miss Flanner, please. Podium, please. Yeah, that's all right. That's all right. Just personal space here. Miss Flanners, would you raise your right hand with me? Also, our elected prosecutor, Mr. Kerner, is in the courtroom. Ms. Flanners, you promise to tell the truth, the whole truth, nothing but the truth, so help you God. Thank you. You can put your hand out, but try to keep your voice up or maybe get to that microphone as close as you can. Maybe, Mr. Plymers, you and Ms. Flanners can switch spots there, and then she can get on that microphone. So this is not Mr. Dillon. It's not your counsel, right? It's a different guy.
No, Your Honor, I am with the Dillon Law Group.
Oh, you are with the Dillon Law?
I'm sorry
okay.
if I not made it clear.
No, nothing was made clear to me at all.
I apologize about that. Yes. So I'm with the Dillon Law Group. Mr. Dillon is the owning attorney.
Well, I know that.
So, yes, I am here on behalf of the Dillon Law Group, and I have been with Ms. Flanner throughout the process, Your Honor.
But Mr. Dillon filed the appearance, right?
Yeah, Your Honor, yes.
All right. So why don't you just let me do my thing with Ms. Flanner, if you don't mind. So Mr. Dillon filed the appearance. So according to my record, he's your lawyer. Do you object to Mr. Plymers representing you today on this plea?
No.
No? Is that okay?
You can, yeah.
Yeah, you have to answer.
Oh, yeah, he can represent me.
He can represent you. Again, just get up to the microphone. I got to be able to hear you.
Yes, he can represent me.
Very good. Are you on probation or parole in this court or any other court?
No.
Other than the file that brings us together today, do you have charges pending anywhere else?
Child support?
You have a child support charge?
Yeah.
Maybe?
Are you
okay.
on child?
Excuse me. Excuse me. I got this. You don't have crimes pending anywhere else, charges other than maybe a child support warrant?
Correct.
Thank you. I was given paperwork by the attorneys, plea agreement sheet signed by the attorneys as well as Ms. Flanner, and then a form of advice of rights also appears to have been signed by Ms. Flanner. Mr. Kerner, do you have terms for us?
I do, Your Honor. The defendant will plead guilty to count 1, attempted breaking and entering with intent. The defendant agrees to pay restitution joint and severally with the co-defendant in the amount of $2,277.
Can I have that number again, please?
$2,277. And that's joint and several with her co-defendant. There's no objection to treatment court if eligible. Prosecutor agrees to dismiss count 2, and the estimated sentencing guidelines are 0 to 9 months.
Thank you. Mr. Plymers, is that your understanding of the plea agreement?
That is my understanding, Your Honor.
Thank you. Mr. Kerner, would you read that count into the record, please?
Certainly, Your Honor. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and location described above, the defendant did, count 1, attempt breaking and entering a building with intent, did attempt to commit the following listed offense, and in the attempt did an act towards the commission of that offense, but failed in the perpetration or was prevented in the execution thereof, contrary to MCL 75092, breaking and entering with intent, did break in and enter a building, to wit, a daycare center located at 701 South Norton Street, Corunna, Michigan, with the intent to commit a larceny therein, contrary to MCL 750110. This is a felony punishable up to 5 years and against the peace and dignity of the state of Michigan.
Mr. Kerner, if you would make an offer of proof to me, I'm confused how there can be attempted B&E, but then the property was missing.
I am confused too, Your Honor, because it was bound over as an attempt. I don't know if we charged it as an attempt.
Do you see my problem?
I do too.
Normally, there'll be a reduction to an attempt, and then you take a factual to the higher to get the lower. Mr. Plymers, do you know why?
I'm unclear as to why, Your Honor.
Oh, we'll see what happens as we get through the plea. Then, Miss Flanner, I think we're at you. You're up now. Did you hear what was placed on the record with respect to a plea?
don't really understand a whole lot of it, but I believe it was probation.
We're not there yet.
Oh.
Let's start with this. I'm told that you're willing to plead guilty to count 1 of the information brought against you by the people of the state of Michigan. And that count 1 is attempted breaking and entering a building with intent. That's a felony punishable by up to 10 years imprisonment. And then I'm told that not only are you willing to plead guilty to that, but you're willing to pay restitution in the amount of $2,277. Is that your understanding?
Am I saying it?
Yeah, that is what we talked about.
Yes.
Are you sure?
Yes.
Okay. Mr. Kerner estimates your sentencing guidelines to be 0 to 9 months on the minimum. Did you hear him talk about your guidelines?
Yes. Sorry.
Did you hear him use the word estimate when he was discussing your guidelines?
Yes.
You got to understand, Ms. Flanner, that the court will score the accurate guidelines as we get close to your sentence date. This is just an estimate. If the court's guidelines that it scores later are different than 0 to 9, you wouldn't be able to withdraw your plea on that issue. Do you understand that?
Yes.
The next thing we need to talk about are this issue about treatment courts. The people are not objecting to you coming into a treatment. You know what a treatment court is?
Yeah, vaguely. Yeah.
Are you prepared for a plea today?
Yes.
You are prepared?
Nervous.
That's okay to be nervous. I just want to know that you're prepared. The attorneys talk to you ahead of time so you know what's happening?
Yeah.
All right. Drug court, mental health court, swift and sure. Okay. The people are not objecting to you coming into a treatment court, but it's not totally up to them. It's up to me. Right? And I don't know anything about you. This is the first time I met you. I don't know whether or not you could come into a treatment court because I don't know anything about you.
Right.
But I can assure you that by the time we get to your sentence date, I will know everything there is to know about you to make a decision whether or not you should come in. It'll be a drug and alcohol assessment, risk and needs assessment, things like that. The process will be fair, I promise you. I just can't tell you today whether or not this is going to happen for you. Does that make sense to you?
Yes.
If the court decides, Ms. Flanner, that you're not going to come into a treatment court for whatever legal reason, you wouldn't be able to withdraw your plea on that issue either. Do you understand that?
Yes.
Do you have any questions about the terms of the plea?
No.
Is that what you want to do?
Yes.
Other than what was placed on the record here moments ago, Ms. Flanner, has anybody made you any promises to get your plea guilty?
No.
Mr. Plymers, are you aware of any promises not placed on the record? Mr. Kerner.
I'm not, but I might have some clarification as to the charges, Your
Please
Honor.
clarify.
So she was originally, the allegation was that they attempted to break into Elite Learning Center, her and her co-defendant, and they were on camera attempting to break into Elite, which is a daycare center. They were unsuccessful and stole some items in a trailer that was nearby.
Oh, okay, that makes sense. So they tried to break into daycare and they couldn't get in, so they took some stuff that was outside.
Correct.
That's as an offer of proof. We don't know yet for sure. We'll check it out. Okay, that makes sense to me. Ms. Flanner, has anybody threatened you or any members of your family to get you to plead guilty today?
No.
Are you pleading guilty to attempted B&E, breaking and entering a building with intent because you are in fact guilty of committing that crime?
Yes.
Has your attorney, Mr. Plymers, left the final decision as to whether or not to plead guilty up to you?
Yes.
Has he talked to you about the different choices that you have to resolve this matter?
Yes.
That includes a jury trial and all that entails.
Yes.
Have you concluded then, Ms. Flanner, that this plea offer made by the people and accepted on your behalf by your counsel is in your own personal best interest?
Yes.
Do you understand that once the court accepts your plea, you give up or you waive your automatic right to appeal? Do you understand that?
Yes.
If you wanted to appeal these proceedings, then you would have to ask permission from another court to appeal or review. Do you understand that?
Yes.
Do you have any questions so far?
No.
I do have a form for Mr. Plymers captioned Advice or Rights. Ms. Flanner, when I look at that form given to me by your attorney, there's a printed name on the bottom. It reads Courtney Flanner, and then there's a signature above it. Is that your signature?
Yes.
Did you read all the rights that are listed on that form before you signed it?
Yes.
Before you signed it, did your attorney, Mr. Plymers, make himself available to you to answer any questions you might have or address any concerns you may have about any of those rights?
Yes.
Finally, Ms. Flanner, before you sign the Advice or Rights form, did you in your mind knowingly and willingly waive those rights?
Yes.
Do you have any questions to the court regarding your rights?
No.
Do you have any questions to the court regarding anything that touches and concerns the plea?
No.
Are you ready to move forward?
Yes.
How do you plead to attempted breaking and entering a building with intent?
Guilty.
If we go back to the time and date set forth in the information, Ms. Flanner, what happened on February 17th of the year 2026 that makes you guilty of that crime? What'd you do?
I was sitting on a.
I can't hear you.
I was sitting on a brick wall. And.
What crime is that?
I don't know.
You have to tell me what you did that amounts to attempted breaking and entering with intent.
I don't know.
Did you try to break into a childcare?
No.
You didn't?
I didn't.
You didn't? Yes or no?
No.
Pass on the file then. We'll set this matter on for trial. Thank you.
Thank you, Your Honor.
It's an incredible waste of time, Ms. Flanner. Why didn't you tell me you weren't guilty when I asked you? Are you pleading guilty
I
because
was
you're guilty?
there.
Pardon me?
I was there.
Unprepared.
I'm sorry, I'm confused.
You are unprepared for court. And counsel, you should have had this meted out with her before we came onto
We
the record.
did, Your Honor, so I'm not
I'm
sure where
sorry.
the confusion is and where her missteps were at, Your Honor, but we did have a thorough conversation about this, Your Honor.
I'm sorry.
You want to try again or are we done?
Yeah.
Yes, we're done, or yes, you want to try again?
Yes, I'll try again.
Okay, what'd you do that makes you guilty of attempted breaking and entering a building with intent?
I tried to enter a building.
How'd you try to do that?
I turned the doorknob.
Oh, well, that's a little bit different than sitting on a wall, right?
Yep.
Why didn't you say that when I asked you?
I'm nervous.
Okay. So you were at a daycare. Where is this daycare? Childcare. Where is it?
Corona.
Corona? That's in Shiawassee County?
Yeah.
What time of day or night were you there?
I don't know what time it was. It was nighttime.
It was nighttime? So did you purposely go at night because you didn't want anybody to see you?
No.
No?
It was that time of day, and
It was that. Would you have tried to break in a building in the middle of the day?
No.
Would you rather do it at night? It's a fair question, isn't it?
It's not like I do that all the time.
But this time?
I don't know what to say.
About choosing the time of your crime? So there's no thought in your mind as to what time you went to this facility. Would you have tried to break into a childcare facility when there were kids in it?
No.
So you would go when it's closed, right?
Yeah.
And probably at night where people can't see you. Does that make sense?
Yeah.
Did you go with other people?
There was one other person, yes.
What was your intent when you went to the building?
We were looking for a bathroom.
Pardon me?
I was looking for a bathroom.
That is it. Pass the file. This is silly. It is silly. You'll be remanded to the custody of the sheriff. All set.
Thank you, Your Honor.
My gosh. Pass the file, schedule it for trial. That's how it goes. Wait, what? I'm full on moron right now. Ladies and gentlemen, I'm your lone wolf Uso. I'm sitting here trying to get things turned on that aren't turned on because I forgot to turn them. That's my fault. Nobody else's fault. But we had a big night tonight, starting the night off with Judge Dad, all that crazy crap he had going on. Messing stuff up like that, dude. It's just how I do things. Yeah. I didn't have the wolf head thing. I don't know what I'm doing here. I just stream. I don't actually pay attention to things. Set things up. Make sure things Hi, y'all. We're at the end of it. But it's not the end of it all. Because if you are interested in some more court cases, then we're going to have some more court cases over on the Wolfbot channel. We're doing a Throwback Thursday, and I am 90% to actually, I'm 100% sure that Judge O'Donnell is playing live over there right now. As a matter of fact, I should probably share a link just in case anybody's in. Just in case. Here you go. Have one of these. We'll be redirecting over there, but you're welcome to take the link over there. Chat will be continuing over on the Wolfbot channel. And we're going to be watching some of Romulus in Memorex. Thank y'all for coming out and hanging out watching Judge Dad, Judge Simpson, and Judge Stewart. Man, they had some dockets today, didn't they? People have been testing Judge Dad all week long. I don't even know what to say about it. Thank you very much, Stephen. Man. And Judge Simpson, he's been getting a little tested too. Judge Stewart, it seems like every single time I watch something from Judge Stewart, you know, it is what it is. It's court. They're not putting on an act for anybody. They're doing business day in and day out. That's kind of what makes it interesting. For now, I have people to thank. And how I do that is a little something like, thank you everybody so much, especially our VIP supporters, Nina Out of the Blue, Wendy Creek, Swah, Julie Sassy, Tammy Tianki, Mary Beth, and always, of course, Rhonda, Barry, Mama Wolfie, Felix, Jen, Allie, Kier, Shiloh, Steven, and Michael. Oh my gosh, I'm out of breath. Thank you all so much. We'll be back here tomorrow night. We got one more night. It's Friday, and then we're doing a brunch on Saturday, like we always do. So come on by again. I'll have more court cases. For now, I'm your lone wolf Uso, and I am out. Rub it up, dub. I'm done. There's nothing else. Go chat with Wolfbot and the other channel for a while. Oh God, I gotta turn that on. Bye.